Mr. Howard back in 2015 and 2016, okay? How long did Mr. Howard have that decision-making power on when Shannon Stillwell would be indicted on the 2015 case?
Well, presumably all the way up until the last day of 2020. I believe that was the last day he was in office. I could be wrong about that, but it would have definitely been around that time.
And who took over that decision-making power in 2020?
The current DA, Fonnie Willis, and her and her agents, people like myself and Adam Abadi and Pat Dutcher.
Okay. So when Ms. Love asks if you delayed the indictment to get a tactical advantage on Shannon Stillwell, it wasn't even your decision, was it?
That is correct. That is correct.
That question about choosing when to indict from 2015 to 2020 should be asked of Paul Howard, correct?
I cannot.
Objection, Your Honor.
Basis.
The question about whether or not the decision to indict should have been left to Paul Howard is not proper. It does not speak to Deputy Sprinkle's actions and steps that he took during this investigation in order to make sure that it was thoroughly vetted.
They tried to create the impression that Mr. Sprinkle's the one that called the shots, and he's clearly not. And now that I've asked him about it, and it's clear he didn't, now it's irrelevant. They asked him if he delayed the indictment of Shannon Stillwell. I'm saying it was delayed, and my client has been prejudiced, and I want to hear from the person who made that decision.
Well, it's one factor that I'll weigh, Mr. Shart, so go ahead and move on. Because we've had another district attorney since then, and it's part of the overall investigation. So his response might be, I'm assuming it's correct, but certainly has to be looked at in terms of the continuum of other things that went on in this case. So, and I'm sure you're going to examine him about those.
Yes, Your Honor. And so starting in 2020, the decision-making was DA Fonnie Willis.
2021, yes.
2021. All right. Okay. When was Shannon Stillwell charged in this case?
I believe it was September 2015.
Okay. And if I suggested it was October 2015, would you dispute me on that?
No, I wouldn't.
Okay. And would you dispute that he was arrested in October of 2015?
I'm quite sure it would have been around that time, the last quarter of 2015. Based on when I received the case file, that would be in line with that.
And he was placed in jail?
He was.
Okay. Now, my client, Mr. Stillwell, was charged in 2015, October 2015. Who else did you say was charged at that time?
Antonio Sledge, briefly, because his case was dismissed at the preliminary hearing.
Okay.
Kenneth Copeland and Demikian Garlington.
And that's the same Kenneth Copeland that is on the state's witness list?
Yes.
Okay. And it was Detective Thorpe of APD that made the decision to charge my client, Mr. Stillwell?
Yes.
And it was Detective Thorpe of APD who made the decision to charge Mr. Sumlin, Mr. Copeland, and Mr. Garlington?
Mr. Copeland, Mr. Garlington, I believe you meant to say Mr. Sledge?
Sledge, I'm sorry.
Yes, yes.
I said Sumlin instead of Sledge.
Yes.
And you're telling us that the decision to charge those 4 individuals was based on the word of Spencer Wright?
Well, for 3 out of 4 of them, if my memory serves correctly, it was essentially entirely based on Spencer Wright. Your client, there was a little bit more evidence.
And we're going to get to that, and I appreciate you bringing that up. So, but for the other three, well, for all four, a man named Spencer Wright claimed to be at the scene of the murder and named those people as being involved.
Yes.
And when Spencer Wright, are you aware of the circumstances that brought Spencer Wright into contact with Detective Thorpe to tell Detective Thorpe this?
Generally, yes.
Did Spencer Wright have pending charges?
Spencer Wright had been, if my memory serves correctly, I know that he didn't just show up to the precinct out of the goodness of his heart. He had been pulled over, if I remember correctly. During the traffic stop, he threw a gun away in the bathroom at the gas station. He lied about his name, and there was an investigator, Lakia Gaither, just happened to recognize him and reminded him of what his name actually was. So he was, so he had a firearm, and I believe he had a probation violation warrant. So he was taken into custody contemporaneously with his statement.
And so we're clear, you wouldn't dispute that Spencer Wright had a motive to lie?
Yes.
That would be correct?
Yes.
Okay. And Spencer Wright actually came in at the same time that he named these four individuals as being involved in this murder and gave police a false name?
He did at first, and one of them, like I said, just happened to know him. And this is all from memory, but I'm pretty sure this is correct.
So he lied about his name?
He did.
And the police knew this?
Yes, they did.
And they took his word on who to arrest on a murder?
That's what happened, yes.
Okay. And through your investigation, you would agree that 3 of the 4 defendants in this case have changed since then regarding the 2015 shooting?
3 out of the 4, okay, so first of all, what do you mean by change, and which 3 defendants are we
There
talking
was
about?
4 people that were charged in October of 2015 by Detective Thorpe. 3 of those 4 people are no longer charged.
Oh, I understand. In other words, we ultimately indict a different set of people than were ultimately charged by the police. Is that your question?
Yes.
Yes, that's correct. We did indict Shannon Stillwell, a.k.a. Shannon Jackson, who's your client, but we did not charge Mr. Copeland, Mr. Garlington, or Mr. Sledge with the murder of Donovan Thomas.
Well, let's be clear. They were charged.
They were charged by the police, yes.
And they were arrested and put in jail
They were, yes.
based on the word of Spencer Wright,
That is correct.
who lied about his name.
He did.
And in those 3 people's place that were eventually released, 3 new people have been charged.
That's, well, 4 people actually, but yes.
Okay. 3 new people and Mr. Stillwell.
Yes.
So essentially what we're saying in layman's terms is Detective Thorpe added 250.
Objection, Your Honor. Relevance
Basis.
and just unnecessary. Detective Thorpe batted 250.
I'm a sustaining objection.
So you have your report, correct?
I do.
All right. And your report is approximately 100 pages long?
140, I believe.
140. Okay. And you began working in January of 2016?
That's correct, yes.
And on page 2 of those 140, well, let me back up. I'm sorry. Almost the first order of business in this report is your concerns about Spencer Wright.
Correct. That is how my investigation began.
Because you were doing a thorough investigation and you looked at the video and noticed the man who was saying he witnessed the event was not where he said he was.
Correct.
And so your report, this 140-page report, begins with discussion of the video and Spencer Wright.
Yes.
On page 2 of the report, in the first paragraph, you talk about Detective Thorpe finding probable cause for these 4 individuals that are originally charged.
Yes.
And then you say, Kenneth Copeland, Demikian Garlington, and Antonio Sledge, or I'm sorry, you say Copeland, Garlington, and Sledge consisted almost entirely of the statement of Mr. Spencer Wright, correct?
Correct.
All right. You went on to say, with respect, or to write, with respect to Mr. Jackson, Mr. Wright also implicated him in the statement summarized below. However, there was another witness named Quindarius Zachary that also implicated Mr. Jackson.
That is correct.
Okay. So on page 2 of the report, you were saying that there was an additional witness against, when I said Mr. Jackson, you were calling a Mr. Jackson report, but it's my client, Mr. Stillwell.
Yeah, back then he was known as Shannon Jackson. That's why I say Shan Jackson, a.k.a. Shan Stillwell, or vice versa.
All right. You, as the investigator, did not have the same doubts or concerns about Mr. Jackson's case or Mr. Stillwell's case than you did with the other 3 defendants, based on additional witness testimony, correct?
Well, I mean, I at least had some evidence that he committed the murder. Yes.
Okay. All right, and just to be clear, in January 2016, when you're working on this case, and throughout your investigation, Shannon Stillwell is still presumed innocent in jail.
He was in jail for about 250 days, I believe, on the murder charge before he was transferred, I want to say, to the Department of Corrections on unrelated matter. But yes, he was in jail, yes.
And he didn't bond out on this case until, on the 2015 case, until October of 2018, isn't that true?
I recall, if I remember correctly, he was booked into the jail on October 23rd and made bond the next day because he had obviously gotten a bond long before then because he had been in jail over 90 days on the murder.
Right, but he was in jail for 3 years.
On the murder?
Yeah.
No, I don't believe he was jailed for 3 years. I believe he was in jail for about 250 days on the
Okay,
murder.
well, we'll say 250 days. I mean, that's a substantial amount of time, correct?
But legally, it's subjective as to what's substantial.
Okay. Well, you wouldn't want an innocent man locked in jail for that long.
Objection, argumentative.
I sustain this deform.
Thank you,
I
Judge.
sustain it.
Okay. Are you an ethical prosecutor?
Yes.
And for the record, I believe Mr. Sprinkle is. Okay. If you felt that there was no case against Mr. Stillwell like you thought about the others, you would presumably have done something to get his release, correct?
Right. What I would have done is I would have told his defense attorneys that essentially there was no evidence, which is what I did with the other co-defendants. So.
Okay.
Right. But with Mr. Stillwell, the absence of evidence wasn't quite as stark.
Okay. And so you didn't take any proactive steps to seek the release of Mr. Stillwell like you did the others?
No.
Okay. How long has, to your knowledge, are you familiar with the internal workings of the Fulton County District Attorney's Office?
Pretty familiar. I've been working there for over a decade, so.
How long has the Fulton County District Attorney's Office been investigating YSL? I can't speak to what the gang unit was doing at around this time. They were in a section of the office to which I didn't have access. Now, if I knocked on the door, if they were there, they would generally let me in, but I didn't just have
I didn't just have unfettered access to their area such that I could wander in at any given point. So they were by design closed off from the rest of the office.
Certainly you were aware generally of whether there was as you were working this Donovan Thomas case, whether there was an active investigation into YSL.
Yes, there was. And so to answer your question, to the best of my knowledge, as far as I knew, or as far as I can remember, the investigation into YSL really started with the murder of Donovan Thomas.
Okay, so 2015. And what about investigations into Jeffrey Williams?
Objection, Your Honor. Relevant?
I'm alleging that this has been a strategic decision to withhold the prosecution of Shannon Stillwell, who they claim to have had a case with, or against, a solid case against, since 2015. And I want to know why they waited 8 years to bring this
Well, then
case.
why don't you ask him?
Well, I want to know what
I'll
investigation.
overrule the objection. Go ahead and go ahead and ask him, please.
To your knowledge, how long have you had an investigation ongoing, when I say you, the Fulton County District Attorney's Office, against Jeffrey Williams?
For me personally, it would have been around, I want to say April of 2016 when I found out that he rented the car that was utilized in the drive-by shooting.
Okay. What about, not you personally, the Fulton County District Attorney's Office?
That I can't answer. As far as I know, I don't know. I have no idea. If there were any other investigations regarding Mr. Jeffrey Williams, I don't know about them.
Well, could you answer if you knew, do you believe that you were the first person to begin an investigation into Jeffrey Williams, or do you believe that there was already investigations into Jeffrey Williams?
Objection, Your Honor. Relevance into investigations regarding Jeffrey Williams.
I'll sustain the objection.
Thank you, Your Honor.
Did you have discussions with Paul Howard about the Donovan Thomas case?
Yes.
How often?
Well, there would obviously, every few months, actually. Maybe there were times it would actually be more often than that. It was definitely not one or two. I can tell you that. It was more than that.
Was he familiar with the facts of the case as alleged?
Yes.
Would Mr. Paul Howard have had access to the gang unit of the district attorney's office that you did not have unfettered access to?
I would presume yes. I guess I never asked him, nor did he ever tell me. It never came up, but given that he was the head of the entire office, I would assume that he had access to every room of the office. But I'm only assuming.
Do leaders of different units within the office meet with each other?
Yes, yes.
Is there coordination between units in the district attorney's office?
Yes, of course.
Was there coordinations between units back in 2015?
Yes.
Could there have been discussions that you were not privy to about these matters?
I'm sure.
Okay. Mr. Sprinkle, you have, is it fair to say that you largely have an investigative function within the district attorney's office?
Well, yes, for the most part.
But you all are also an attorney.
I am.
You have a bar card.
I do.
You're familiar with the laws of, the rules of evidence in Georgia?
Yes.
Okay. You would agree that we're in here today not on a murder case, but a large RICO case, which one part of it has an alleged murder?
I am familiar with the indictment that is before the court, that is being litigated right now, and I am familiar that the primary or the first count or couple of counts is a RICO case. As far as I'm concerned, I was primarily, if not really exclusively, concerned with the murder of Donovan Thomas.
Correct. But you are aware that this indictment that we're all in here today involves more than just the 2015 shooting of Donovan Thomas.
I'm aware of that, yes.
Okay. And there are 4 people that you chose to charge and indict. Well, we'll get to that. There's 4 people that you advised the state to indict for the murder of Donovan Thomas.
Well, I believe there are 5, and I was definitely part of meetings regarding the indictment. But again, this is really Don Geary that was leading the charge on who to indict for the murder. Now, was I influential? Of course, but I wasn't the one who ultimately made that decision. But
You weren't the one to make the decision. When was this case ready to take to the grand jury? The alleged murder of Donovan Thomas.
well, it wasn't an alleged murder. He absolutely was murdered. It was May of 2022.
It wasn't ready?
No, wait, when was the case presented to the grand jury?
When was it ready to take to the grand jury?
I can't, again, because Don Geary was the attorney that was working on that, and I wasn't, well, I guess it was ready when we presented it, right? I would assume.
Well, that's when your office chose to present it.
Yes.
I'm asking when it was ready.
I don't, you would have to ask Don Geary that.
Okay.
Because as you said, this is more than just the murder of Donovan Thomas. This is a big RICO case, so.
I'm aware of that, but I'm very interested in when the singular incident, the January 2015 shooting of Donovan Thomas was ready to present to the grand jury.
I would just have to say May of 2022, unless you can define the word ready a little, with a little more specificity.
That's when your office decided to present it, is your answer.
Right, correct.
Mr. Sharp, hold on one second.
You received credit for each of those days as to the newfound offense for which you got 10 due 3, went off to prison, came back, found it out next day. The only time he was only in there that I'm aware of. My information was.
He was also arrested for this stuff.
I don't know if he was arrested. He was in jail for those things. In the sense of like I wouldn't necessarily. I can argue the book and everything. I just he received credit for every one of those days towards his sentence. For those other crimes.
This right here.
He was also arrested for drug charges that had nothing to do with it. I don't have the separate drug charges. Not for that. No, I can't help you with that. I would just ask. No, do it. Do it. Do what you can. No. No.
I'm not doing it all. Yep. Okay.
All right, go ahead, sir. I'm sorry.
Thank you, Your Honor. May it please the court once again. You're aware of the rules of evidence in Georgia,
Yes,
okay, that dictate what is admissible at trial?
that's correct.
Okay. You are aware that the rules of evidence are different for a RICO case, correct?
That's correct.
You're aware that typically in a criminal case, quote unquote, bad character evidence is not admissible against a defendant.
With exceptions governed by 404B.
Right. And 404B, propensity evidence would not be admissible under 404B.
No, it's motive, intent, knowledge, plan or scheme, preparation, absence of mistake or opportunity.
You're aware of the fact that my client, Mr. Stillwell, because this is a RICO case, is being tried for 2 murders at the same time, correct?
I am familiar with the second murder from earlier this year, yes.
You're also aware that because this is a RICO case that was indicted in 2022, my client is accused of over a dozen overt acts that are listed in the indictment.
I am generally aware of the format of the indictment. I haven't studied it. If you're telling me that then I'm sure that's true.
You would agree that oftentimes, if people are simultaneously accused of 2 separate crimes, they receive different trials for different crimes, correct? Different allegations.
Well, it would depend on if it was, for example, a crime spree based, temporal proximity being very close that the incidents are almost considered one continuous incident, then you may indict them together. But particularly given the length of time between the 2 incidents, you would generally indict them separately, correct?
Okay, so, and you're aware that the other murder that is alleged against my client is from 2022.
Correct.
You would agree that that would not have temporal proximity, correct?
No, I would, no, if these were just 2 completely independent murders, I would not put the 2015 murder on the same indictment as the 2022 murder. They'd be 2 different murders under normal circumstances.
As a lawyer, can you see where that would be prejudicial against my client?
Well, yes, I suppose if you were to have 2 murders on the indictment, then the jury would be told initially that there was a finding of probable cause on not 1, but 2 different murders. And so I can understand that.
What about evidence being presented and discussed about the actions of other individuals for things that occurred years after 2015? Would those typically come in for a murder that happened in 2015?
Well, it would depend. If it was a gang-related murder, maybe. Because, when there's a gang charge that's placed on somebody, then there's a lot more evidence that can come in related to the street gang.
What about if your office decided to indict this 2015 incident in a timely manner and didn't wait till 2022? Would this case have
Objection, Your
already been
Honor.
tried?
Objection as to speculative and argumentative.
I sustain the objection.
Are you, through your investigation, did you come across a gentleman by the name of Termon Stillwell?
I did. Yeah, Detective Thorpe and I spoke with him, I believe, in early 2016.
Okay, and Termon Stillwell, who found Termon Stillwell?
I believe it was Detective Thorpe. It wasn't me, so it must have been Detective Thorpe. And I don't recall how he learned about Termon Stillwell.
Ever ask Detective Thorpe about the circumstances on how he found Termon Stillwell?
Objection, Your Honor, as to the relevance.
Yeah, what's the relevance, sir?
I mean, this is the investigation we've been talking
Hold on,
about.
Mr. Sprinkle, what's the,
This is the investigation we've been talking about, that we admitted this report as part of, and I'm asking about the investigation. I'm cross-examining the investigation.
I'll rule the objection. Go ahead, Mr. Sprinkle.
Thank you, Your Honor.
Go ahead and answer that.
So if I remember correctly, he was in the Fulton County Jail. Well, we interviewed him at APD, but he was brought over from the Fulton County Jail. Contemporaneous with his arrest, he told, and from what I remember, he definitely told somebody with the Atlanta Police Department that he had information on the murder. And if I remember correctly, it was the members of the Apex unit. They may have been the ones that arrested him. But at any rate, he said something to some police officer that he knew something about the murder. That got back to Detective Thorpe, so Detective Thorpe told me about it, and then Detective Thorpe transported him from the Fulton County Jail to APD where we interviewed.
Did you ever talk to the member of the Apex unit to confirm that they were the ones that had first contact with Tremont Stillwell?
I don't recall.
And Tremont Stillwell, he was in jail for what?
Family violence battery, I believe?
Okay. Felony?
I don't remember if he was a recidivist or not. It may have been. I just don't remember.
And who was he accused of battering, beating?
I think it was his wife, if I remember
What's her
correctly.
name?
That I don't recall.
Would it be Vanetta Guffey?
That's it.
Okay. And so Mr. Stillwell, Tremont Stillwell, let me be clear. Tremont Stillwell came to your attention, and did you have an opportunity to speak with Mr. Stillwell?
I did.
And when was this?
March 22nd, 2016.
So we're still back in 2016.
We are.
Okay. And did Mr. Tremont Stillwell claim to know my client Shannon Stillwell?
Yes, I believe he said that they were relatives. They were related. Like Mr. Stillwell, Tremont Stillwell, said that he was his cousin, if I remember correctly.
Did you ever confirm that there was any family relation?
Well, apart from their last name being the same, or one of Mr. Stillwell's, Shannon Stillwell's last names, because he was known as either Jackson or Stillwell. I mean, even back in 2016, I knew that was one of his aliases. I was never completely clear as to which name was actually his name, Shannon Jackson or Shannon Stillwell.
Okay, well, let's just benefit of the doubt, it's Shannon Stillwell. Did you ever independently, other than they had the same last name, confirm that there was any relation between the two?
I don't remember.
But Tremont Stillwell claimed that he was Shannon's uncle.
I thought it was cousin.
Cousin. Okay.
Yes.
Cousin. And Tremont Stillwell was in jail at the time that he met with you guys, correct? I know that you brought him over to APD headquarters, but he had pending charges.
That's correct.
Okay. And he gave you some information he claimed could be used against Shannon Stillwell.
That is correct.
Okay. And he claimed that back in 2015, Shannon Stillwell ran up to him while he was walking with his wife in the park.
That is correct.
Did he indicate which park?
I don't recall the park. I just recall it being August, or it was sometime during the fall of 2015 that Tremont Stillwell, as he strolled through the park with his wife, Miss Guffey, he came upon Shannon Stillwell, who complained of getting shot at some point in the very recent past, and that the reason for this was that he had participated in the murder of Donovan Thomas.
Okay, and according to Mr. Stillwell, according to Tremont Stillwell, Shannon Stillwell said that Kenneth Copeland, the state's witness, was also involved.
That I don't. Yeah, actually, I think he did say that. Now that you mentioned. Yes.
Okay. And if Tremont Stillwell was to be believed, that would be a confession coming out of Shannon Stillwell's mouth.
A third-party confession. Yes, sir.
Okay. And of course, as we saw with Mr. Wright, Mr. Stillwell, Tremont Stillwell, had pending charges at this time.
He did.
And as an investigator, you wanted to corroborate what Tremont Stillwell was claiming that he had witnessed.
That's correct.
And you were also aware that there were many street rumors going around at that time?
There were, yes.
Okay. So you sought to corroborate the statement of Tremont Stillwell,
That is correct.
and you decided to call in Miss Vanetta Guffey to talk to her about the situation, correct?
That is correct.
Okay. And speaking of Vanetta Guffey was important because she was the person that Tremont Stillwell claimed was his wife,
That's correct.
and that Tremont Stillwell was claimed was present when Shannon Stillwell supposedly made this statement, correct?
That is correct.
Okay. And you were able to speak with Miss Vanetta Guffey, correct?
Yes, I believe, I definitely remember speaking with some female after that Tremont Stillwell interview, and it was related to that interview, and it didn't go very well.
Okay, now, Mr. Sprinkle, I want you to know that I have no objection, of course, subject to the judge's rulings, to you referring to your notes to answer these questions.
I'm actually referring to the Exhibit 11 to...
Your report.
Right.
Right, and I have no objection to that at all. So we're clear on this. What page are you on?
Oh, well, the pages aren't numbered, but I'm on the page that starts with on May 11, 26. Oh, well, it just so happens I'm on the right page.
All right, cool.
All right, so it was on May 11, 2016 when Detective Thorpe and I interviewed Vanetta Guffey on the 7th floor of my office, the DA's office.
Okay. And you said it was you and who that interviewed her?
Detective Thorpe, Jim Thorpe Jr. with the Atlanta Police Department.
And how did you get Miss Guffey to come to your office?
I don't recall. I believe if I had to, hold on, let me see.
Did you tell her it was about Tremont Stillwell's case about him beating her?
I believe so. That sounds right.
Okay, so is it, and I'm not suggesting it's illegal for you to do this, but you misled her about why you wanted to speak.
Well, I mean, as a practical matter, I mean, that it was a legitimate area of inquiry as well. She was a victim on a case, but, you know, we didn't want to tell her about the murder, because she didn't even know that she was part of the murder investigation yet. So to get her into the office, we thought it would be better to just not tell her about that part, and rather just tell her about the case in which she already knew she was a witness.
Okay, fair enough. And you eventually told her you wanted to speak to her about this case.
That's correct.
And did you tell her that Tremont had said that she may have witnessed something?
I did.
Do you remember exactly how you worded it? I shouldn't say exactly. Can you paraphrase how you worded it if you don't remember exactly?
I asked her about Shannon and asked her if she knew of Shannon. She said that she did, that she considered him her little nephew. And she also said she wasn't fond of Tremont Stillwell because, going back to the case in which she was a victim, because of him beating on her. At the time of the interview, Mr. Tremont Stillwell was still in the Fulton County Jail. All I remember is that when we brought up Shannon, her mood, she was relatively pleasant at the beginning of the interview. And, you know, after we discussed the battery and moved on to Shannon, she was, her mood changed. Shannon Stillwell, your client, her mood changed rather dramatically. In fact, it culminated in her storming out of the room and basically running out of the office.
Right. And she made it clear to you that you shouldn't believe a word that Tremont Stillwell says.
She called him a liar.
Right.
She, as she stormed out, I believe she called him a liar.
He's unreliable.
Right. That's what she said.
And you don't dispute that Miss Guffey knows Mr. Tremont Stillwell very well.
No, she knew him pretty well. I mean, she was a victim on a family violence battery case, so you have to know somebody pretty well to be considered a victim of a family violence offense.
Okay.
Mr. Sharp, before you pose your next question, how much longer do you think you'll have?
I was about to ask like 3 more questions.
Oh.
Unlike Mr. Menendez, I think I'm being...
Who's 2 is not really 2?
Right.
Okay, all right. Okay, well, I'll be the judge of that, okay? This is number 1
Uh-oh,
coming up right
pressure
here,
on.
okay?
Pressure on. Mr. Sprinkle, did Miss Guffey indicate to you that she was not... Did she ever indicate to you that she had heard Shannon Stillwell say anything about a murder?
No. Without even refreshing my recollection, I mean, the interview ended pretty abruptly after she realized that we were asking about Shannon Stillwell. It wouldn't have even got... She was no longer participating in the interview, essentially. Towards the end, I was trying to ask her questions as she ran away from me, so...
She told you that she doesn't know anything about the statement that Shannon Stillwell allegedly made to Termon Stillwell.
That's correct.
That Termon Stillwell claimed that she witnessed.
That's correct.
Okay. Are you aware of where Miss Vanetta Guffey is now?
Well, I've been told, and this I haven't independently verified it, but as of yesterday, it's my understanding she's deceased.
Okay.
She didn't die yesterday. I learned about it yesterday.
Right. I beg the court's indulgence just briefly. Mr. Sprinkle, you, as part of your investigations, do you stay abreast to what's going on at 901 Rice Street?
Well, yes, particularly with respect to the jail calls.
Okay. Are you aware that there have been multiple attacks on my client, Shannon Stillwell, since, and when I say attacks, stabbings, she's been incarcerated this year?
This year?
Yes.
No, I wasn't aware of
Are
that.
you aware of multiple attacks on Shannon Stillwell while he's been incarcerated?
Objection, Your Honor, as to relevance,
It's,
as to whether or not the defendant has been
Prejudice.
attacked.
he's been incarcerated for a long time, and it's certainly relevant that he's
It
being
is.
attacked.
I'll overrule the objection.
I remember a time in late 2015, which would have been around the time he was arrested. He was actually a witness on a murder case. And he was in the same area of the jail as some rival gang members. That's about all, and that there was an issue with that, but that's about all I remember. I don't remember anything about him being attacked.
Are you aware that he's on 23-hour lockdown for his own safety at this time?
No, I didn't know about
Okay.
that.
I don't have anything else, Your Honor. Thank you. Thank you, Mr. Sprinkle.
All right, Madam, Ms. Love,
Thank you, Judge.
it's about 1:30. Can we take a comfort lunch lunch break to 2:15? And then we'll resume at that point in time, okay?
Thank you, Your Honor.
All right. We're going to be recessed until 2:15, and we'll come back at that point in time.